Hi guys, welcome back to my channel Rahul Study. In this video, we just talk about the leading case regarding the discharge of a contract. In this case, you just learn about the destruction of a contract. What is the meaning? There are two sections regarding this case. You just refer 56 and 32 of the Indian Contract Act. Regarding this fact, you just go through that section, you will be able to understand the meaning of the discharge of a contract or destruction of contract. Whenever two party or more than two party get into contract uh, for the same object, like for a building, one party gave offer to sell his own building and another party accept that offer. Okay, I will purchase your building, but due to some circumstances the building get into destruction by any other activity, like act of god, anything, then the object not possible within the time limit to build again that building. Then here the destruction of a contract would happen, or discharge of a contract would happen. But in this case, the defendant Mugneeram Bangur and Company Limited and the Satyabrata Ghose, the plaintiff. The let's see the how the fact of this case. What is the fact of this case? What is the legal issue of this case? And how the judgment has given by Supreme Court itself, because this case came into Supreme Court. As you can see, All India Report, the citation of this case is the All India Report 1954 Supreme Court. So guys, let's start. Before I start, please subscribe this channel and press the bell icon to get notification on time. You can also join my Telegram channel Rahul Study, same as YouTube channel, to get this PDF from that Telegram channel. This PDF is known as this PDF is actually a case material provided by Delhi University for the first year LLB student. So you can also open while I'm going to read this fact of the case, all aspect of this case. So you can also open your Bear Act law of contract LB. You can just go see the see the code of the course code and open your 148 page. Okay guys, I'm going to read. Justice Mukherjee, BK Mukherjee gave this judgment regarding this case. Okay, Satyabrata Ghose versus Mugneeram Bangur and Company. All India Register 1954, Supreme Court 44. The fact giving rise to this appeal are, for the most part, uncontroverted, and the dispute between the parties centers around the short point as to whether a contract for the sale of land to which this litigation relates was discharged and come to an end by reason of certain supervening circumstances which affected the performance of material part of it. To appreciate the merits of the controversy, it will be necessary to give a brief narrative of material facts. The defendant company, that is Mugneeram Bangur and Company, which is the main respondent in this appeal, is the owner of a large tract of land situated in the mini city of the Kuria Lakes within Greater Calcutta. The company started a scheme for development of this land for the residential purposes, which was described as Lake Colony Scheme Number 1, and in furtherance of the scheme, the entire area was divided into a large number of plots of the sale of which offers were invited from intending purchasers. So there is a company come with a scheme named as Lakh Colony Scheme number 1. The scheme purpose is land divided into number of lots number of plots and its sale over the purchaser or people. Let's see the facts. The company's plan of work seemed to be to into agreement with different purchaser for sale of these plots of land and accept from them only a small portion of the consideration money by way of earnest at the time of the agreement. The company undertook to construct the roads and drains necessary for making the land suitable for building and residential purposes. As soon as they were completed, the purchaser would be called upon to complete the conveyance by payment of the balance of consideration money. Vijay Krishna Vijay Krishna Rai, who was the defendant number 2 in the suit and figures as a pro forma respondent in this appeal, was one of such purchaser who entered into a contract with the company for purchaser of a plot of land covered by the scheme. His contract is dated the 5th August of 1940 and he paid 101 as in earnest money. In this receipt granted by the vendor for this earnest money, whose terms of agreement are thus set out. Okay, received with thanks from Babu Bijoy Krishna Rai of 28 Toligun Circular Road, Toligun, the sum of 101 rupees only as earnest money, having agreed to sell him or his nominee 5,000 more or less in plot number 76 on 20 and 30 feet road in promises no lakh colony scheme number 1 southern block at the average rate of 1000 per quota. The conveyance must be completed within 1 month from the date of completion of the roads on payment of the balance of the consideration money. Time being deemed as the essence of the contract. Time being deemed as the essence of the contract. In case of default, this agreement will be considered as cancelled with the forfeiture of earnest money. Mukarari Morausi terms of payment: one third to be paid at the time of registration and the balance within 6 years, bearing arrears 6% interest per annum. On November 30th, 1941, the plaintiff appellant was made a nominee by the purchaser for purposes of the contract, and although he brought the present suit in the character of a nominee, it has been held by the trial judge as well as by the lower appellate court that he was rely as assignee of Vijay Krishna Rai in respect of the latter's right under the contract. Sometime before this date, there was an order passed by the collector 24 Paraganas on 12th of November 1941 under the Rule 79 of the Defense of the India Rule, on the strength of which a portion of land covered by the scheme was requisite for the military purpose. Requisitioned means the temporary period. For temporary period, government was assigned the land for the military purpose. Meanwhile, another part of the land was requisitioned by the government on 20th of December 1941. Then the fact arises by the party, while a third order of requisition, which related to the balance of the land comprised in the scheme, was passed sometime later. In November 1943, the company addressed a letter to Bajai Krishna informing him that requisition of the lands by the government and the starting inter alia at a considerable portion of the land appertaining to the scheme was taken possession by the government, and there was no knowing how the long government would retain possession of the same. The construction of the purposes roads and drains therefore could not be taken up during the continuance of the war or possibility for many years after its termination. In these circumstances, the company decided to treat the agreement for sale with the addresses as cancelled and give him the option to taking back the earnest money as he want to take the as 101 rupees as earnest money. That in the case the purchaser refused to treat that contract as cancelled, he could, if he liked, complete the conveyance within 1 month from the receipt of the letter by paying the balance of the consideration money and take the land in the condition in which it existed at that time. The company undertaking to construct the roads and the drains as circumstances might permit. After the termination of the war, the letter ended by the saying that in the event of the addressee not accepting either of the two alternatives, the agreement would be deemed to be cancelled and the earnest money would stand forfeited. This letter was handed over by Vijay Krishna to his nominee, the plaintiff, and there was some correspondence after that between the plaintiff on the other hand and the company on the other through their respective lawyers, into the details of which it is not necessary to enter. It is enough to state that the plaintiff refused to accept either of the two alternatives refused offered by the company and stated categorically that the letter was bound by the terms of agreement from which it could not in law resile. On 80th January of 1946, the suit out of which this appeal arises was commenced by the plaintiff against the defendant company, to which Vijay Krishna was made a party defendant, and the prayers in the plaint were for a twofold declaration, namely, one that the contract dated 5th of August 1940 between the first and the second defendant, or rather his contract dated either his nominee, the plaintiff, as was still subsisting, and second, that the plaintiff was entitled to get a conveyance executed and registered by the defendant on payment of the consideration money mentioned in the agreement and in manner under the conditions specified therein. Now, the suit was resisted by the defendant company, who raised a large number of defenses in the answer to the plaintiff's claim. most of which are not relevant for our present purpose. The most material plea was that the contact of cell stood discharged by frustration as it became impossible by reason of the supervening events to perform a material part of it. The trial judge of his judgment dated on October 10 1947 overruled all the plea taken by the defendant and decreed the plaintiff's suit. An appeal taken by the defendant to the court of the district judge of 24 Pragans was dismissed on 25th February 1949 and the judgment of the trial court was affirmed. The defendant company thereupon preferred a second appeal to the High Court, which was heard by a division bench consisting of Das Gupta and Lahari, Justice Das Gupta and Lahari. The only question canvassed before the High Court was whether the contact of sale was frustrated by the reason of requisition order issued by the government. The learned judges answered this question in the affirmative in favor of the defendant. On that ground alone dismissed the plaintiff's suit. The plaintiff has now come there before the before us on the strength of a certificate granted by the High Court under the Article 133 Clause 1 Clause C of the Constitution of India. The learned Attorney General, who appeared in support of the bill, has put forward a threefold contention on behalf of his client. He has contended in the first place that the doctrine of England law relating to frustration of contract, upon which the learned judges of the High Court based their decision, has no application to India in view of the statutory provision contained in Section 56 of Indian Contract Act regarding the destruction or frustration of contract. Just go through that section, guys. I will also going to read that section. Wait. You can see a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promiser could not prevent, uh, unlawful, becomes void. When the act becomes impossible or unlawful, compensation for loss through non-performance of the act known to be impossible or unlawful. Simple, this section said to be the if the contract becomes void, then it's becomes impossible, and when a contract becomes impossible, then it's becomes void. Simply, this contract section 56 uh, says if a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promiser could not prevent, unlawful becomes that contract void. So just one more section we just have read, section 32 of Indian Contract Act. Section 32 of Indian Contract Act, enforcement of contract in contingent on an event happening. So guys, something contingent contract is related to that fact. So just read this section also. Contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contract becomes void. So in contingent contract also contract becomes void, and in con- impossible contract also becomes void. So these two sections just read with section 56 with section 32. Let's see the 133, article 133 clause 1. Let's see the article 133 only. Okay, this article regarding the appellate jurisdiction of the Supreme Court in the appeals from High Court uh, in regarding the to civil matter. Okay, okay, let's continue. The learned Attorney General who appeared in support of the appeal has put forward a threefold contention on behalf of his client. He has contended in the place that the doctrine of English law relating to frustration of contracts, upon which the learned judges of the High Court based their the decision, has no application to India in view of the statutory provision contained in Section 56 of Indian Contract Act. It is argued in the second place that even the English law applies, it can it can have no application to contract for sale of land, and that is the fact of the opinion expressed by the English judges themselves. His third and the last argument is that on the admitted fact and the circumstances of this case, there was no frustrating event which could be said to have taken away the basic of the contract or rendered its performance impossible if any sense of the word. The first argument advanced by the learned Attorney General raises a somewhat data debatable point regarding the true scope and effect of Section 56 of Indian Contract Act, and to what extent, if any, it incorporates the rule of law, the English rule of first session of contract. Section 56 occurs in Chapter 4 of Indian Contract Act, which relates to performance of the contract, and in it purports to deal with the one class of circumstances under which the performance of a contract is excused or dispensed with on the ground of contract being void. The section stands as follows: an agreement to do an act impossible in itself is void. An agreement to do an act impossible, that act impossible, that itself, that agreement void. A contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promiser could not prevent, unlawful, becomes void. When the act becomes impossible or unlawful, when one person has promised to do something which he knew or with reasonable diligence might have known, and which the promisee did not know to impossible or unlawful, such promiser must make compensation to such promisee for any loss which such promisee sustain through the non-performance of the promise. So the first paragraph of the section lays down the law in same way as England in England. It speaks for something which is impossible inherently or by its very nature, and no one can obviously be directed to perform such an act. The second paragraph initiates the law relating to discharge of contract by reason of supervening impossibility or illegality of the act agreed to be done. The wording of this paragraph is quite general, and though the illustrations attached to it are not at all happy, they cannot derogate from the general words used in the enactment. This much is clear that the word impossible has not been used here in the sense of physical or literal impossibility. The performance of an act may not literally impossible, but it may impractical and useless from the point of view of the object and purpose which the parties had in view. And if the untoward event and change of the circumstances totally upsets the very foundation upon which the parties rested their bargain, it can very well be said that the promiser finds it impossible to do the acts which he promised to do. Okay, although the various theories have been propounded by the judges and the jurists in England regarding the jurisdiction basic of the doctrine of frustration, it the essential idea upon which the doctrine is based is that impossibility of performance of the contract. In fact, impossibility and frustration are often used as the interchangeable expression. Impossibility and frustration are often used as interchangeable expressions. The changed circumstances is said to make the performance of the contract impossible, and that party are absolved from the further performance of it, and they did not promise to perform an impossibility. The parties shall be excused, as Lord Loreburn says. See Tamplin Steamship Coal Limited versus Anglo-Mexican Petroleum Products Company Limited, 1916. If the sustainably, if the sustainably, the whole contract becomes impossible of the performance, or in other words, impractical by some cause of which neither was responsible. In Joseph Costani Stephenson Line Limited versus Imperial Smelting Corporation Limited, 1942, the doctrine of frustration is only a special case of discharge of contract by an impossibility of performance arising after the contract was made. Lord Peter agreed with the view rested the doctrine on the same basis. The question was considered and discussed by the division bench of the Nagpur High Court in Kesari Chand versus Governor General in the Council, and it was held that the doctrine of frustration comes into play when a contract becomes impossible of the performance after it is made on account of the circumstances beyond the contact of the parties. The doctrine is a special case of impossibility, and such comes under the section 56 of the Indian Contract Act 1872. We are in the entire agreement with this view, which is fortified by a recent pronouncement of this court in Ganga Saran versus Ramcharan, All India Report 1952 Supreme Court. at 11, where Justice Fazil Ali, in speaking about the frustration observed in his judgment as follows: it seems necessary for us to emphasize that so far as the courts in this country are concerned, they must look primarily to the law as embodied in Section 32 and 56 of Indian Contract Act 1872. We hold therefore we hold therefore that the doctrine of frustration is rely an aspect or part of the law of the discharge of the content by reason of supervening impossibility or illegality of the act agreed to be done, and hence comes within the purview of Section 56 of Indian Contract Act. It would be incorrect to say that 56 of Indian Contract Act applies only to cases of physical impossibility, that whether this section is not applicable, recourse can be held to the principle of English law on the subject of frustration. It must be held also that to the extent that the Indian Contract Act deals with the particular subject, it is exhaustive upon the same, and it is not permissible to import the principle of English law. Therefore, this statutory provision, the decision of English courts, possesses only a persuasive value, and the decision of English court possesses only a persuasive value and may be helpful in showing how the court in England have decided cases under the circumstances similar to those which have come before our courts. It seems necessary, however, to clear up some misconceptions which is likely to arise because of the complexities of the English law on the subject. The law of the first station in England developed, as we all know, under the guise of reading implied terms into the contracts. The court implies a term or exceptions and treats that as part of the contract. In the case of Taylor versus Codwell, Blackburn first formulation of the doctrine in its modern form. The court there was dealing with the case where a music hall in which one of the contracting parties had agreed to give concerts on the certain specified days was accidentally burned by fire. It was held that such a contract must be regarded as the subject to a implied condition, that is, the party shall be excused in case before the breach performance becomes impossible from the punishing of the thing without the default of the contractor. Again, in Robinson versus Davidson 1871, there was a contract between the plaintiff and defendant's wife as the agent of the husband that she would play the piano at a concert to be given by the plaintiff on the specified day. On the day in the question, she was unable to perform through illness. The contract did not contain any term as to what was to be done in case of her being too ill to perform. In an action against the defendant to breach the contract, it was held that the wife's illness and the consequent incapacity excused her, and that the contract was in its nature not absolute but conditional upon her being well enough to perform. Bromwell B. Bromwell pointed out in course of his judgment that in holding that the illness of a defendant incapacitated her from the performing the agreement, the court was not really in gratifying a new term upon an express contract. It was not that the obligation was absolute in the original agreement, and the new condition was subsequently added to it. The whole question was whether the original contract was absolute or conditional, and having regarded to the terms of the bargaining, it must be held to be conditional. The English law passed through the various stages of development since then. The principles enunciated in the various decided authorities cannot be said to be any way uniform in many pronouncement of the highest court in England. The doctrine of the frustration was held to be the decided by which the rules of the absolute contract and reconciled with the special exception which justice demands. Vijay Hariji Mujli versus Cheong Yop Steamship. The fact of this case that the second contention raised by the Attorney General can be disposed in view of words. It true that the England the judicial opinion generally expressed it that the doctrine of frustration does not operate in case of contacts for the sale of land. But according to Indian law, which is embodied in Section 54 of the uh, of Property Act, a contract for sale of land does not of itself create any interest in property which is the subject matter of a contract. The obligations of the parties to a contract of for sale of land are therefore the same as in other ordinary contract, and subsequently there is no conceivable reason why the doctrine of frustration should not be applicable to the contract for the sale of land in India. This contention of Attorney General must therefore fail. We now come to the last and the most important point of this case, which is raised the question as to whether, as a result of requisition order under the which of the comprised in the development scheme of the defendant company were requised by government, the content of the contract of sale between the defendant company and the plaintiff procedure is to dissolved by the frustration in order other words becomes impossible of performance. It is well settled and not disputed before us that if and when therefore there is frustration and resolution of the content occurs automatically. It does not depend as does decision rescission of a contract and the ground of reputation or breach of or choice or election of either party. It depends upon the effect of what has actually happened on the possibility of performance of the contract. So we will now proceed to examine the nature and terms of the contract before as the circumstances under which it was entered into the determine whether or not disturbing the element which is alleged to have happened here has substantially prevented the performance of contract as a whole. It may be stand at the outset that the contract before us cannot be looked upon as an ordinary contract for the sale purchase of a piece of land. It is an integral part of a development scheme started by the defendant company and is one of the many contracts that have been entered into by large number of the person with the company. The object of the company was undoubtedly to develop a fairly extensive area which was still underdeveloped and make it usable for residential purposes by making roads and the construction drains through it. The purchaser, on the other hand, wanted the land in the regard to which the entered into the contract to develop and made ready for building purposes before he could be called upon to complete the purchase. The most material thing that which deserve notice is that there is absolutely no time limit. This is the thing, guys. You just go through it. There is no limit time within the roads and trains are to be made. The Leland district judge of Alipore, who heard the appeal from the trial court's judgment, found it as a fact on the evidence in the record that there was no even the understanding between the parties on this point. As a matter of fact, the first requisition order was passed nearly 50 months after the contract was made, and apparently no work was done by the defendant company. In the meantime, another important thing that requires notice in this connection is that the war was already on when the party entered into the contract. Requisition order for the taking and temporary possession of the land for war purposes were normal events during this period. It is temporary event. Apart from the requisition order, there were other difficulties in doing the construction work at that time because of the scarcity of materials and the various restriction which the government had imposed in respect of them. That's that there were certain risks and difficulties involved in carrying the operation like this. Could not but be the contemplation of the parties of this contemplation of the party of this time when they entered into a contact, and that is probably a reason why no definite time limit was mentioned in the contract within which the roads then are to be completed. This was the left entirely to the convenience of the company, and the matter of the fact purchaser did not feel the concerned about it. It is against the background that we are to consider to what extent the passing of the requisition order affected the performance of the content in the person's case. Now, the company, it must be admitted, had not commenced the development work when the requisition order was passed in November 1941. There was no question therefore, of any work as service being interrupted for an indefinite period of the time. Undoubtedly, the commencement of the work was delayed, but was the delay going to be so great and such a character that it would be totally upset and basis of the bargain and the commercial object which is the parties had in view. The requisition order, it must be remembered whereby their very natural and the temporary character of the requisition authority could be in law occupy the position of the licensee in regards the requisition property. The order might continue during the whole period of the war and even the some time after the that, or it could have been withdrawn before the war termination. If there was no definite defined limit agreed by to the party within which the construction work was to be finished, it could be said with the perfect property that the delay for an indefinite period would make the performance of the contract impossible within the specified time, and this would seriously affect the object and the purposes of the venture. But when there is no time limit whatsoever in the contract, nor even the understanding between the party on the point on which the make the carrying of the operation more tiredly and difficult, that in the timepiece we do not think that the order of the frustration operation order of requisition affected on the fundamental basis upon which the agreement rested or struck at the roots of the adventure. The London judges of the High Court, in deciding the case against the plaintiff, relied entirely on the time factor. It is true that the parties could not contemplate an absolute ultimate period of time to fulfill their contract. sorry, they might continually have in mind a period of time which was reasonable, having regard to the nature and magnitude of the work to be done, as well as conditions of war prevailing at the time. In our opinion, having regard to the nature and the terms of contact, the actual experience of war condition at the time when it was entered into, the extent of the work involved in the development scheme, and the last through not the least, the total absence of any definite period of the time agreed by the party within which the work was completed. It cannot be said that the requisition order has vitally affected the content or the made its performance impossible. In our opinion, that the events which have happened here cannot be said to have made the performance of the content impossible, and the content has not been frustrated at all. The result is that the appeal is allowed. The judgment and the decree of the High Court Kolkata are set aside. Those of the content be below restored. So thank you so much. This was the case regarding the frustration of contact. Just go through the section provided by this case, that is 32 and the 56 of Intercontact Act, and Transfer of Property Act 54, which says that the land shall not come under the frustration, this type of thing. Just go through that some section, guys. Thank you so much again for watching this video. Bye bye, take care, have a nice day.